Allow me to emphasize that we need not be sensational when considering the importance of this bill. South Africa, under the ANC-led government, has had to tighten its regulatory framework against the loss of over estimated 15 trillion in the last 50 years, and an estimated loss of over 750 billion annually in the African continent as a result of illicit financial outflows. These statistics, members, are conservative, as they are obtained from the IMF Direction of Trade Statistics. They could be more. These figures exclude intangibles such as proceeds of corruption, drug trafficking, people and arms trafficking, etc. This May 2016 being the Africa Month, the cost of illicit outflows happens at the backdrop of the increasing number of Africans living in abject poverty. By 2010, the UN estimated that 414 million Africans live on less than $1.25 a day. The Africa Development estimates that Africa needs an additional 50 billion needs 50 billion to finance infrastructure backlog in Africa. Therefore, Chairperson, we felt strongly that we needed to make sure that this bill is fast-tracked because it's been there since 2009, and it actually undermines our agenda to prosper all South Africans. And as such, we are calling on all South Africans to align themselves with the African Union's slogan of preventing capital outflows, which is track it, stop it, get it. Chairperson, in considering the Financial Intelligence Center Amendment Bill, the Committee on Finance had to confront the reality that South Africa operates in an open economy, international finance space. Chairperson, it is very important for all members to understand that we have to stop the illicit outflows. We have to ensure that we stop all leakages to the public purse. The African National Congress-led government subscribes to the natural laws of progress, revolution of thought, prosperity for all, and most importantly, global integration and alignment in order to confront and defeat the ends of injustice which threaten our public purse. In 2003, South Africa joined the Financial Action Task Force after enacting a Financial Intelligence Center number 38 of 2001. We had to benchmark ourselves against the best in the world as we realized fighting corruption, money laundering, financial terrorism, and illicit financial flows requires a strength of global force. Chairperson, the bill addresses the following areas which have already been covered by members, and I'm glad that all the political parties generally accepted the importance of this bill, notwithstanding some of the lamentations and so forth. Chairperson, these are the areas that the bill addresses: enhancing the customer due diligence requirement for accountable institutions, thus making suspicious transactions detectable and dealt with accordingly. Therefore, members and South Africans at large, we are inviting you to comply when requested by banks and other legitimate institutions to provide the proof of address and when asked questions relating to beneficial owner, because this is actually in the best interest of us as a whole. Institutions are now compelled by this very law to stringently perform due diligence on customers and continuously monitor transactions. This legislation adopts institutions such as institutions such as banks, the entire financial sector, estate agencies, legal, accounting firms, and many other firms that are potential conduit of illicit financial flows, and to ensure that records are kept and continuously, and we monitor continuously all transactions. The bill provides for the adoption of risk-based approach to customer due diligence. Members, we have to understand that banks at times, they are going to be doing things that we may not like. because sometimes they will have to freeze our own assets if they have grounds to suspect that we are involved in some kind of money laundering or illicit financial flows. This bill, members, removes reference to Counter Money Laundering Advisory Council, which, as said, has been dissolved owing to the fact that there are a number of platforms within each country from which to discuss matters of concern and of mutual interest. Of critical importance is that this bill, members, this bill strengthens cooperation between government and accountable institutions, especially banks and firms, in effectively mitigating against risk which contribute in weakening the country's financial position. The bill enhances supervisory powers. However, it is important to note that FIC will be done consistent with the Protection of Personal Information Act 2013. It's also important to understand that we have to give effect to the Constitutional Court decision in the matter of Estate Agencies Affairs Board versus Auction Alliance Ltd, which in essence made clear that the Section 45B of FIC Act is unconstitutional. Therefore, the bill, consistent with the court order, provides for a warrant requirement and to state in which circumstances a warrant would not be required. The bill, therefore, members, expands the definition, as other members have already said, of beneficial holder. It also clarifies who is the legal person. It also further unpacks in depth the domestic prominent influential person, executive officer, foreign prominent public official, etc. This is done in order to avoid ambiguities and to ensure that the bill is actually enforceable. Members, the National Treasury has had to consult widely, and even the committee also consulted widely on this particular bill, because it does have certain implications. As also already alluded by Umazambane, that there were certain aspects of the bill that we had to deal with. Umazambane phela wangasekhaya kwaZulu noma nje esawelela ngaphesha wayeyiqabane, by the way, former president weNUSAS lo, but ke uyaganga nje.
Honourable member, your time has now expired.
Chairperson, finally, Chairperson, the ANC supports this bill and would like it to be adopted. Comrades, let's
Thank you, Honourable Member.
And get it.